So, at this point, where does that leave me? Same place. Suspended for now, maybe later disbarred. The biggest irony of my eternal suspension at this point is the last time I applied for reinstatement, Robert Saltzman accused me of being a racist in his papers because I alleged that there was Jewish favoritism going on. In 2002, I requested reinstatement to the New York State Bar, and who opposes it? Who puts in an affirmation but the Jew Robert Saltzman? And what does he say? Let's see. He notes that let's see. It is also clear that notwithstanding the discipline, I continued to behave in frivolous, bizarre, and racist litigation. Racist litigation. Because I brought a complaint, a federal district complaint, in federal court, which I didn't know you couldn't bring, because when you're suspended or disbarred, you can only go to the U.S. Supreme Court. Grab another complaint is that certain members of the staff, members are Jewish. And by virtue of that, I was denied an impartial hearing. And Justice Sterling Johnson dismissed my complaint, and he indicates that because I brought up my complaint regarding white Christian males being denied, it's further evidence of irrational prejudice and direct conflict with the disciplinary code, prohibiting attorneys from lawfully discriminating in the practice of law. That's kind of interesting. So in other words, if you accuse a Jew of discrimination and bias, who is in the grievance committees or on the courts, if you say, well, you're doing this because you're Jewish and I'm not, you are deemed a racist. How interesting is that? You cannot, according to my denial of reinstatement, if you accuse a judge who's a Jew of discriminating against you because you're not Jewish or your client is not Jewish, that is prohibiting lawyers from that is acts which show that you unlawfully discriminate in the practice of law. It's kind of astounding if you think about it. So at this point, why make the video then? It's because I'm not the person the Jewish bar and the Jewish courts say I am. The evidence is here in the clip. Evidence can be ignored. People can just look at the suspension order. But if you look at this video, the evidence cannot be disputed. I also made this video so people can see the danger of permitting Jews to control our judiciary. When they control the judges, they control the attorneys. There is also, you should note that there is also a great danger in permitting the judges to control people's access to the court. Now, when a person who has the ability to practice law, when they are prohibited from being an attorney, the only avenue of appeal from the state is to the U.S. Supreme Court. That's not the case in most professional licenses. You got a problem, you can go to the district court, I'm pretty sure. The U.S. Supreme Court has never reversed one attorney suspension, attorney disbarment, or attorney non-admittance. An appeal from a state decision regarding an attorney is final. An attorney's profession is not protected by the U.S. Constitution. Please also note that an attorney is also prohibited from publicly criticizing judges' ability or their fitness or bias or racism. You do that, you're going to end up suspended, disbarred, whatever. What this really means to all you out there is that an attorney must approach the court and speak to the court on bent knee. And they have to do this when they're supposed to be representing their client's interest, not kowtowing to the court. It is not surprising that presently there are very few attorneys of great notoriety who are fighting on behalf of people. Judges have been cutting attorneys down when they stand up against the corrupt system or the biased or corrupt judges. Judges who are the government simply should not be the gatekeepers of a person's First Amendment right to petition the government for redress of grievances. The court is often the last nonviolent hope for anyone seeking redress. If the First Amendment truly means anything, it means a person's admission and retention to the bar should not be determined by the judiciary. Attorney admissions and retention process should be done by professional licensing boards similar to licensing boards of real estate brokers, mortgage brokers, nurses and doctors, engineers. Engineers, brokers, nurses, doctors, they have due process protections because a determination at a state agency is subject to U.S. constitutional review. Attorneys, however, serve at the leisure and whim of judges. In other words, the attorney you hire is a mere extension of the judge you find yourself standing before. One simply cannot serve two masters. This particular letter is interesting. It's from somebody who used to be one of the counsels in the Grievance Committee in the First Department. And she was fired, Christine C. Anderson. She alleges corruption. She was for 6.5 years. She was principal attorney in the First Department. She found that people investigating and disciplining attorney, they were found guilty. Let's see. She discovered that acts of misconduct and corruption, which constitute an abuse of power and fraud, and she was summarily terminated. So she made these. She wrote her letter to all these people. In 2007. And nothing came of it. Big surprise. Know why? Because the courts can do whatever they want with regard to attorneys. Just somebody should be interested in this. Take a look where this went. What were the allegations? Talk to us.